welcome everyone. Lovely to welcome you today for today's session, Regulatory and Legal Compliance in Pharma Manufacturing Agreements. I'm delighted to be joined today by my colleague, Tom Cahill, a senior associate, very experienced lawyer in supply and manufacturing agreements in the pharma supply chain, and also delighted to welcome Regina Dawkins, an associate director and senior consultant at PharmaLex, a leading regulatory specialist consultancy in pharma and life sciences. So what we're going to do now is I'm going to hand over to Tom in a minute. We're going to hear from Tom on the legal side. Then we're going to hear from Regina on the regulatory side. And then for the last quarter of an hour or so, we will have opportunity for Q&A. So without further ado, I would like to now hand over to Tom.
Thanks, Paul. So in the first part of this webinar, we're going to be looking at certain legal issues which often arise in relation to pharmaceutical manufacturing agreements. Some of the issues will be relevant to other types of pharma supply agreements, but the main focus will be on manufacturing contracts. I'll mention a few examples from previous deals I've been involved in, and I'll give you some tips for negotiation and drafting. The usual lawyer's caveat will be looking at things from an English law perspective. So in terms of sort of overall approach to negotiations, I mean, often the contract is seen as an insurance policy, essentially, if there is a dispute. And to a degree that is right, but a well-drafted manufacturing agreement, which sort of clearly sets out each party's rights and responsibilities, can hopefully reduce the risk of a dispute happening in the first place. And in terms of quality, I mean, we often see a lot of sort of first drafts coming out of industry, which are, shall we say, sort of, capable of improvement. And my sort of general advice is, to you is to be bold where you can. I mean, if the other party's first draft is not great and you've got better templates yourself, then you can suggest stripping out the key commercial terms and putting them into your own template. And, if that's not possible, you can be surprised sometimes, I think, by, the degree of amendment which the other party will accept, if they see that the drafting is clear and, it's going to benefit, both sides to the deal. So, yeah, the basics of the agreement. And the first point is, identifying the parties. So, of course, I mean, you want to know exactly who you are going to be contracting with. So, obviously, it's important to identify each party to the contract precisely. And I recommend setting out each party's full name, registered office or principal place of business, the company registration number, assuming that that party is a company, because obviously the company names can change over time, but the company number will remain the same. On a sort of separate but related issue, there have been a few sort of recent high-profile examples of people coming unstuck in situations where the party they thought they were actually contracting with was acting as an agent for the principal, who was sort of, essentially sitting behind that agent. So it's it's good practice in the warranty section to, to include, warranty from each party along the lines of party X warrants that it is a party to this agreement and not acting as an agent for any third party for the purposes of the contract. Then moving on to sort of background and heading, I think it's good practice to to sort of try and make things easy for anyone picking up the contract a bit further down the line who wasn't involved in the negotiation and drafting. So I always think it's worthwhile putting in the product name or names into the title or header of the contract. And in terms of the background or recital section, it's good practice to put in a brief explanation of each party's general business, their role in the particular contract, a description of the products which are going to be manufactured and supplied, with any sort of brand names and APIs and the relevant territory. In terms of dating the contract, I mean, under English law, it must be dated the date on which you sign it. And you can get into all kinds of trouble, including sort of quasi-fraud if you don't do this. So at the head of the agreement, always put in, the date of, signature itself. But that rule, it's important to sort of, keep in mind that rule doesn't preclude you from backdating the effect of a manufacturing agreement. So if, for example, you've got product which has been ordered or supplied before signature, you can backdate the effect of the contract so those earlier orders are sort of captured under the terms of the contract. Moving on to sort of signature and exchange of copies. I mean, if you're dealing with a UK company, then with a manufacturing agreement, it's almost always fine for both parties to sign through a single director. It's obviously very rare the agreement is going to be set up as a deed, which sort of requires anything more than that. If you're dealing with an overseas company, I mean, the requirements for sort of binding that company to the contract are dictated by the law in its own jurisdiction. So you might need to do a bit of research on that point. For example, does the company need to have two directors rather than one signing the contract? And then, I mean, in terms of sort of, the date for signature, I think, it's good practice if you can just sort of pick a date when all the directors who are going to sign are available. You just get them to sign on the same day, and then you can sort of exchange PDF copies by email. And doing it this way, it should make it easy for you down the line to work out the expiry date of the agreement, because the effective date is very often linked to the date on which the parties sign, and then the term is linked to the effective date. So if those dates are sort of crystal clear, it can really help you further down the line when it comes to terminating or extending the agreement. You know exactly what the termination date is going to be. So appointment, orders, and delivery. And the first point is exclusivity or not. So, I mean, it's always important to sort of very clearly specify whether the agreement is exclusive or not, in terms of both the supplier and the customer. So from the supplier's perspective, is it permitted to be involved in the manufacture of equivalent products for third parties, or is it only allowed to manufacture, that particular type of products, however you define it, for the customer? And obviously, the answer to that is going to depend on, the particular sort of commercial circumstances. I mean, if the supplier is a CMO, contract manufacturing organization, it may well be resistant to giving exclusivity, because they will say, well, it's our business to manufacture products for a range of customers, and we don't want to be constrained in that way. If the contract is something more complex, like a dossier license and manufacturing agreement, then exclusivity may be, the very essence of the deal. In terms of the customer, similar considerations will apply. So if the customer is just buying from a CMO on an arm's length basis, they may well say no to exclusivity. But again, if it's if the contract is something more sophisticated like a dossier license, a manufacturing agreement, then again, the whole deal may well be sort of predicated on exclusivity. I mean, in the situation where the supplier agrees to exclusively supply the customer and no one else, usually that's going to be, in return for the customer sort of making a certain minimum, annual purchases of, of the products at issue. And there are a couple of sort of tips here for the customer if you are under a sort of obligation to buy a certain amount each year. I mean, first you can negotiate a right for yourself to sort of top up purchases after the end of the relevant contractual year. So if you don't meet the target, you can give yourself, a bit of breathing room. So, for example, another 21 days in order to sort of place orders to make up the shortfall. And then you could also ensure that if you don't hit your target for the contractual year, that the only remedy which is available to the supplier is to sort of remove exclusivity or terminate the contract. But, so as essentially not to leave yourself open to a damages claim. So, you just provide, in the event the customer doesn't hit the target, supplier's sole remedy is, to make it non-exclusive or to terminate. And then sort of moving on to the obligation to supply. I mean, obviously from the supplier's perspective, you want to make this as gentle as possible. So you might want to sort of frame it in terms of, well, the supplier will use its reasonable efforts to supply, and it was only going to be required to sort of meet orders which actually meet the requirements of the agreement. And then sort of, you might want to sort of possibly tie in the obligation to, forecasts provided by the customer for its future requirements. In terms of sort of from the customer's perspective, obviously you want it to be a sort of stricter obligation, and you might well sort of frame it in terms, well, if an order complies with the terms of the agreement in terms of how, being sort of sufficiently detailed and complying with the lead time, then so long as the order complies with those terms, then the supplier just has to fulfill the order, perhaps, subject to any sort of force majeure provisions. Moving on to time of the essence. So, I mean, almost always in a pharma manufacturing agreement, there'll be a stipulated lead time from the placement of the order to delivery. And, the customer, will be allowed to sort of select a delivery date so long as it complies with, with the stipulated lead time. Now, in relation to that, you'll often see the phrase used, time is of the essence, which has a particular meaning in English law. And essentially, the effect of the rule is that if the delivery is late by even a single minute, then the supplier is going to be in breach, and the customer then has a right to cancel the order and claim damages. So as the customer, you can sort of push for time of the essence to be sort of tied into the delivery, but don't be surprised if the supplier sort of pushes back on that. And then moving on to sort of variation in quantity. I mean, you'll often see a provision in the contract which gives the supplier a little bit of leeway in terms of the amount of product which is sort of delivered against any sort of particular order. So something along the lines of, the supplier will not be in breach if it delivers between 90 and 110% of the ordered amount. I mean, I think broadly speaking, I mean, that is fair enough. But if there is a shortfall, a drafting tip from the customer's perspective is to include a right either to claim, a price reduction, or to call upon the supplier to deliver the shortfall within a reasonable time frame. I mean, obviously, you don't want to be paying for product which you don't receive. So moving on to quality and the sort of the basic warranty in any sort of pharma manufacturing agreement, that the products essentially have to be kosher and have to be sort of manufactured in the correct way. I mean, usually this is going to say things like, the products have to be undamaged, free from material defects, have at least the minimum unexpired shelf life at delivery, comply with the specifications, the requirements which are set out in the quality agreement, and you can sort of cross-refer to that here. And then, the storage and the manufacture of the products have been done in compliance with all sort of relevant laws, regulations, including GMP, GDP, etc. Now, in terms of sort of defining the specifications for the products, obviously it's very easy for licensed products, because you can just refer to the specifications which are set out in the corresponding marketing authorization. It's a bit more difficult for unlicensed products, and you might need to be a bit more inventive there, in sort of in terms of sort of cross-referring perhaps to an equivalent product in another country where there is an MA, or to the dossier for the product, even if it hasn't been licensed. Moving on to sort of time frame for buyer to object and other requirements. So this section, essentially concerns allegedly defective products, and usually the contract will stipulate a time frame in which the buyer has to object, and there'll be one for defects apparent from a visual inspection. So, for example, 30 days from delivery, and then another time frame in terms of latent defects. So perhaps 14 days from when the defect was discovered. I mean, from a supplier's perspective, you'll always want to sort of make compliance with those deadlines. You want to make the customer's remedies, sort of absolutely conditional on compliance with those deadlines. As a buyer, you can sort of box clever a bit, and with a bit of sort of clever drafting, you can kind of agree to have those deadlines, but not have your remedies sort of absolutely conditional upon meeting those deadlines. And then, in addition to sort of the deadline point, the supplier, sort of a well-advised supplier, should also insist on the buyer complying with sort of certain other requirements. So sort of making the defective units available for inspection by it, the buyer sort of supplying all the relevant paperwork which relates to the order, and requiring the buyer to show that the units in question have sort of been stored and handled correctly following delivery. In terms of remedies of the buyer, usually the contract will specify refund or replacement products. But a good sort of drafting tip for the buyer is to say, right, well, whichever remedy it elects, refund, replacement, that has to be without prejudice to any other rights and remedies which the buyer has. So, for example, if the supplier supplies a load of defective products, patients are hurt, it's not going to be sufficient for the buyer simply to call upon the supplier for a refund or replacement products. Obviously, the buyer is going to want to sue for damages as well. Then, in terms of dispute as to quality, you ought to include, a mechanism in the agreement for sort of dealing with, whether parties cannot agree on whether particular units are defective or not. And usually, you want to sort of refer any sort of dispute to an independent laboratory to have a look at that. So indemnification. So quite often you get, I see contracts coming through with sort of extremely broad indemnities, which essentially say, each party indemnifies the other party for all losses arising from any breach, whatsoever of the agreement. And it's almost as though the draft of the contract thinks, well, if I don't put in an indemnity and there's for a particular type of breach, and that breach arises, then I won't be able to claim for damages. And I mean, under English law, I mean, that's just simply not the case. So at the first bullet point there, we've basically got the English law rule on damages, which applies without any provision, in terms of an indemnity. So you see, I mean, I won't read them out, but I mean, the first, there's the first limb there, which covers essentially sort of direct losses, and then you've got the second limb, which covers indirect but foreseeable losses. And I say you have that right under English law, regardless of any indemnity. So moving on to the basics of an indemnity, I mean, the effect of any given indemnity is going to depend on the way, on its particular terms and the way it's drafted. But the basic rationale for them is to enable the non-breaching party to recover certain types of losses that the general law just doesn't permit. So that's the basic rationale for them. As I say, I think, the kinds of all encompassing indemnities which I just mentioned in terms of any losses for any breach, I think, it's a very dangerous game, for both the supplier and the customer to be playing. And it's much better to limit any indemnity to sort of specific, well-defined categories of third-party claims. So essentially, the non-breaching party gets hit with a third-party claim as a result of the breach, and then the breaching party picks up the tab for that third-party claim. And in the context of pharma manufacturing agreements, I think, it's reasonable for the supplier to pick up the tab for third-party claims arising from the supply of defective products. And then, on the buyer's side, you often see an indemnity for third-party intellectual property rights sort of breaches. If the supplier is hit with that type of claim simply by manufacturing the products, then the buyer picks up the tab. In terms of mitigation, obviously you don't want to be writing a blank check if you're giving an indemnity, so you want a positive obligation on the indemnified party to take action to mitigate. And then, an indemnity is only as good as the party giving it, so you want some good insurance obligations on the other party there. So we can move on to the next slide. Limitation of liability. So, I mean, the basic rationale for such a clause is to protect each party from, a huge claim or a huge series of claims, which is basically going to blow the whole organisation out of the water. I mean, in the context of pharma manufacturing agreements, it's much more important to the supplier than the buyer. I mean, the buyer's principal obligation is simply to pay for the product supply. So there's a lot more at stake for the supplier than the buyer. In terms of legal constraints on limitation, there are certain types of liability which just cannot be excluded under English law. So keep those in mind, and these include fraud, fraud and death or personal injury caused by a party's negligence. Then, in terms of the Unfair Contract Terms Act, this is just a note of caution. If the parties are contracting on one party's standard terms, then any attempt to limit that party's liability has to pass a reasonable test. So if you're the supplier and you're contracting on your own terms and conditions, obviously that's something to bear in mind and sort of to weigh into the balance. If the clause is not reasonable, then it could be struck out by a court. Looking at types of losses and maximum liability. You obviously want to sort of list out the particular types of loss which you are excluding. So, for example, loss of profit. But think about how this clause interacts with other parts of the agreement. So, for example, you often see an exclusion of liability for indirect losses, but then in other parts of the contract, there'll be indemnities, and their basic rationale is to facilitate the recovery of indirect losses. So sort of, think about how the exclusion sort of interacts with other parts of the contract. In terms of maximum liability, obviously you want to sort of set out a maximum cap for each party, probably link that to each contractual year, and you could also link it to insurance coverage. I mean, this was something I saw in an agreement the other week. Actually, the clause set out a particular maximum cap, but it said, to the extent the breaching party's insurance covers the relevant losses, then that particular party's liability is increased by a corresponding amount, which is quite a clever trick of sort of protecting both parties. And then in terms of breach of certain provisions, you sometimes see one party will try and carve out particular breaches, confidentiality, bribery, compliance. Just beware of that, because companies are simply made up of people, and people do make mistakes. So on to the next slide, and I'll try and deal with this very quickly because I can see that time is sort of marching on. So post-termination, you often see, so dossier license and marketing authorization agreements, you often see the same issue, crop up again and again, which is what happens to the buyer's marketing authorization upon termination of the agreement. And I think the thing to do is just to be very clear in your drafting, deal with what happens to the MA, deal with what happens to the buyer's physical copy of the dossier and the buyer's license to use the dossier in all sorts of ways that the agreement can terminate. So through a fluxion of time or material breach, whatever it is. Outstanding orders and unused materials. I mean, obviously as the buyer, you'll be wanting to sort of call upon the supplier to fulfill any orders which have been accepted or even placed prior to termination. Unused materials, sometimes you'll see the supplier wants to sort of put an obligation on the buyer to purchase any surplus materials. Just a note of caution, your new manufacturer might want to source its own. So just a note of caution there. And then transfer to new manufacturer. As the buyer, you want to put some sort of positive obligations onto the supplier to ensure a smooth sort of transfer. And with the supplier's perspective, you'll want to sort of limit that particular assistance. So on to the final slide. And this is, we just thought it would be interesting to run a poll on sort of possible future webinar topics. So there are 4 options. As I understand it, you can vote for one or more of those 4 options. So we've got indemnities, limitation of liability, reasonable and best endeavours, and Pharma distribution agreement. So hopefully, if the technology works, you'll be able to.
Thank you very much, Tom. That was really great. We'll gather the results of the poll, so please keep voting. And without further ado, having heard about the legal side from Tom, now Regina, can you tell us about the regulatory side, please?
I certainly will. Good afternoon, everybody. Thank you for joining this webinar. So this, from my perspective, we're going to look at, what is the requirement of a technical agreement, give you some guidance on measures to ensure we have robust and compliant agreements in place. And this is to ensure that you capture all of your outsourcing activities of manufacturing and supply chain within your pharmaceutical business. If you go to the next slide. So we very much drafted this presentation to align with Tom's presentation. So look at some tips for negotiating agreements, the basic requirements of agreement, looking at responsibilities, the quality contractual requirements, and in this section we look at warranty, remedies, disputes, and our regulatory expectations, and then a brief touch on indemnity. What happens if there are breaches in the agreement and the potential consequences, and then post-termination, what happens next. So for negotiating a quality agreement, the key things are to remember that your contract acceptor has to have the appropriate licenses, systems, and equipment to fulfill the outsourced activities in a compliant manner. So prior to doing your quality agreement drafting, you will have done your qualification process for the outsourced activity. It's also a good idea to add, in some cases, the quality agreement as an appendix to the master or commercial services agreement. This ensures that both are in place and implemented at the same time. So from a regulatory expectation, there should always be a quality agreement, and that should be based on your master services or master commercial agreement. Review the content of the quality agreement in conjunction with the commercial agreement, and this ensures that both are aligned. I have seen cases, we've been on inspections with an MHRA inspector where they've reviewed both the commercial agreement and the quality agreement, and there have been differences in the two. Sometimes what's called out in the master services agreement is not what's actually described within the quality agreement, so that can cause some problems. It's always keep the language simple and use clear and concise instructions. Don't always try to make it a novel. It's always good sometimes to put it into a tabular format where you clearly see what's my responsibility, either as the contract acceptor or the contract giver. And always remember, a clear and concise agreement ensures responsibilities are clearly outlined for both parties with clear defined escalation routes to help avoid any conflicts. And remember, when you're negotiating your quality agreement, the service that you're contracting as the contract giver, remember that is an extension of your supply chain, whether that's a manufacturer of APIs, a manufacturer of finished product. It could be your contract laboratory, your packaging, or your warehouse and distribution provision services. They're all an extension of your supply chain, so it's your responsibility as the contract giver to make sure your quality agreement is robust. So looking at the basic elements, so a typical quality agreement must have its sort of purpose and scope, has clear definitions, clearly defined responsibilities, and always have a contact list. So if I'm fulfilling my duties and I've come across a non-conformance or an issue in the supply chain, how do I know who to contact? How do I know who my counterparty is, say, from a supply chain perspective or from a quality perspective? So always make sure your contact list is up to date, that you list or call out the products or services within the scope of the agreement. It should always be approved by both parties, and it should have a section covering changes and revisions. And it's always important to clearly call out the list of some subcontracted activities. So where you have a manufacturing site, they may subcontract an element of the testing, they may subcontract an element of supply of some of the materials. So please ensure that they are called out within your agreement. The agreement has to define how the parties share responsibilities, communicate, and confirm compliance to good manufacturing, which is GMP, or good distribution practices, GDP, depending on the nature of the agreement that you're negotiating. An agreement between the marketing authorization holder and a wholesale distributor should contain sufficient detail to ensure that pharmacovigilance requirements are met. We are seeing that in industry with inspection findings here in the UK, that is not always captured as part of any wholesale or distribution quality agreements. Remember, it's the responsibility of the marketing authorization holder to decide what provisions need to be included in these agreements. And particularly considering the content required in agreements may vary depending on the parties involved. So remember, you as the contract giver, it is your agreement, you are contracting that service, so you need to define the content and the roles and responsibilities. What I'm going to, I suppose, briefly talk to now is looking at the importance of defining responsibilities. So clear definition of the roles and responsibilities is required. Remember, the contract giver is responsible for implementing the quality agreement between both parties with a clear call out of some of these key responsibilities. So make sure that it includes regulatory compliance, and this is both regulatory compliance in terms of the license they hold, how they manage their license maintenance, and how they report any inspection findings to you as the contract giver. To cover change control and notification of changes to any of the outsourced activities or changes which may impact the quality of that outsourced service or product. Changes in specifications to validated methods, processes, delivery or transport options. Looking at recall, complaints, adverse events and safety reporting, and notifications and communications with the MHRA regarding the contract giver's product. So this is a clear one, I think, to draw your attention to, is that as a license holder, your contracted parties, your contract acceptor, whether that is a manufacturer, a lab, or a wholesaler, they have a license as well. So if there is something that potentially impacts your product, but it impacts their system, they have a responsibility to also report to the MHRA. So just to make sure there's a clear responsibility and the rules and the approval of communication to the MHRA regarding your product. And also cover clear reporting of thefts and losses or any subcontracted activities by the contract acceptor. We've seen cases recently where a product has, potentially gone missing or been lost. It has been reported by the marketing authorization holder, but it hadn't been reported by the site from where it had gone missing. So that has resulted in some citations within MHRA inspections. Is their expectation that product where it is lost or stolen, so if it is at the manufacturing site, they should be the ones reporting as well as the marketing authorization holder. So some expectations of the UK inspectors to the MHRA. So the expectation is a quality agreement must be in place between the contract giver and the contract acceptor for all outsourced activities. The agreement must clearly define the roles and responsibilities of both parties, and the activities should be aligned with the commercial or master services agreement. The agreement should be periodically reviewed, and normally the expectation of this is every 2 to 3 years, depending on the complexity of the outsourced activity. And this review should include changes to personnel, facilities, license, products or services that should be reflected within any revision of a quality agreement. Agreements should define the reporting timeframes for complaints, recalls, and adverse event reporting. For GMP agreements, the qualified person certifying the product to market should be a signatory on the quality agreement. And for wholesale agreements, the contract giver and the contract acceptor's responsible person or responsible person for import should be a signatory on the agreement. The MHRA are looking at how often agreements are reviewed. They're finding, a lot of agreements are outdated. They revert back to maybe previous master services agreements. You have people leave the business, or you make changes to your license that you do not reflect in a quality agreement, and these can result in citations during inspections. So briefly then, indemnity. From my perspective, I think it was just care, showing some caution here and care when you define the limitations of liability. And this is in particular to the limitation of responsibilities in relation to recall, thefts, losses, and communications with the MHRA. So the responsibility for recall and thefts and losses ultimately lies with the marketing authorization holder, but the contract acceptor will have a responsibility to report thefts and losses to the MHRA, and in the case to the Home Office if it is a controlled drug within the UK, when a theft or loss has occurred whilst the product is in their control. And the expectation from the MHRA is that the reporting of thefts and losses should be made by both the contract acceptor and the contract giver. So in these cases, the initial reporting would be made maybe by the contract acceptor while the loss has occurred on their premises or while they're transporting your product. But the expectation is as well, as the marketing authorization holder, you will also report that to the MHRA. So breaches in the contract and the potential consequences. So any breach in a quality agreement could result in a regulatory non-compliance, and that could potentially impact the product quality or the patient safety. Because remember, at the end of the day, your quality agreement is part of supporting your quality supply chain, which is in turn impacting or supporting the safety of your patient. because when we're talking about pharmaceutical products, we have to remember the person at the end of all of this, the end of our chain, is a patient, and the patient usually has a health problem or may have a compromised immune system. So failing to communicate changes in the license scope can impact regulatory compliance. So if your contract acceptor made some changes to their license where they were not permitted to provide batch release activities, or if they were not permitted to perform importation activities, that's a regulatory non-compliance. Whilst it's a regulatory non-compliance, that could then prevent the release of your product to the market, which could result in a shortage to the market. So uncommunicated changes in premises, equipment, or subcontractors can inadvertently impact product quality and potentially patient safety. And these types of changes can be changes to validated or registered product parameters. So it's maybe changing the composition of a tablet or capsule. It's changes in facilities where that could impact the labeled storage requirements if you increase the heating system or the cooling system within your facility. Is that impacting your client's label storage requirements of their product? Changes to equipment impacting dossier and physical product parameters, changes in validated testing methods, and changes to subcontractors could potentially introduce non-GMP or GDP compliant parties into your supply chain. And that's I suppose very clear to understand if there is an issue with the supply chain of your contract acceptor and they're further subcontracting the activity, you as the marketing authorization holder have the responsibility to ensure that the supply chain is robust throughout the journey of your product. Then, so post-termination. So what happens when a quality agreement is terminated? One of the key aspects from a quality perspective and regulatory perspective is looking at the GMP and GDP documentation and the data transfer to the contract giver or the marketing authorization holder. Remember that all batch manufacturing and testing records need to be transferred, and these will be archived records, because remember that the requirement from a GMP and GDP perspective is that you retain documentation for up to 7 years after the product has left your premises. But if that product has been used within clinical trials, there is a requirement potentially to hold documentation for a period of 15 years. So the termination of agreement can result in the transfer of a large volumes of documentation, both electronically and physically. It's how your QMS data is transferred. And all this will include your PQRs, your audit reports, your supply chain data for orders and delivery notes, any product returns, how product destruction will be handled, and then the updating of the contract giver's license to remove any terminated parties. And that is a key thing to remember. So my poll is basically asking you a question, what you would like to hear about from PharmaLex in terms of future topics. So there are 4 choices. So writing effective and robust quality agreements, supply chain mapping, how to understand your supply chain, vendor approval and management, and wholesaling and distribution agreements.
Thank you very much, Regina, and thank you again, Tom. Now, I've had a few questions that have come in. The first one, actually, I think this is for Regina. So, Regina, back onto you. So the question is that you said that if there should be a review every 2 or 3 years of the technical agreement, should that also apply to the commercial agreement?
Not necessarily. What you will see, a commercial agreement is quite a long, lengthy legal document, so it may not be reviewed for a number of years. But the expectation for the MHRA, we have seen instances in the recent years where commercial agreements were in place maybe in 2004 to 2010. The inspection was in 2020. So the expectation would be that that's quite a length of time, but you would have a review of the renewal. So you would have a letter or an amendment to the agreement to say that it has been reviewed and no update is required.
Okay, thank you very much, Regina. Good, very clear answer on that. Next one, yeah, this is for Tom. Tom, you said that the supplier should have a limitation of liability clause, but should the buyer also have a limitation of liability?
I mean, yeah, I think the short answer is yes, it should, but you just want to sort of think about sort of keeping the level of protection that the limitation of liability gives you sort of commensurate to the risk to the buyer. So in a very sort of simple manufacturer and supply agreement, I mean, the buyer's sort of key responsibility is simply to pay for the goods. So, you know, the risk is low. In a more sophisticated agreement, such as a dossier license and supply agreement, you know, the buyer's risk will be high because they may be doing things like applying for marketing authorizations as well. So you may want more protection from your limitation of liability. And I also think sometimes there's a danger from the buyer's perspective that they think, well, what is good for the supplier is good for me. So, you know, for example, you know, a supplier will often look to protect itself from, you know, sort of in terms of excluding loss of profits, you know, liability for the buyer's loss of profits, but it doesn't necessarily hold that, you know, the same should apply for the buyer, because if the supplier isn't making any profit from supplying the products, then, you know, it sort of loses the you know, the basic, you know, thrust of the agreement. So I think the short answer is yes, but just keep it sort of, you know, commensurate with your risk.
I think that's a very good answer, Tom. And in fact, I might chip in on the next one as well, as because I also do some work in supply manufacturing agreements on the legal side. But I agree with you exactly on that, Tom. Generally, it's more in the supplier's interest than the buyer's to limit liability. But sometimes, as a matter of, oh, they like to make it mutual, and actually, do they always know what their liability is for? But for the buyer side, if it's a pure manufacturing agreement, you know, it's their main obligation is to pay. I've had another question here, and I'm not reading out the names of the question submitters because this is being recorded and this is going to go out on the YouTube channel afterwards. So the question is regarding linking limits of liability to a party's insurance level, can that result in the insurer trying to deny liability under the insurance policy? And maybe if I take that one first, and Tom, if you've got any thoughts on that as well, actually stipulating in the liability cap that the cap is the same as the insurance, that could be a problem anyway from a legal point of view, because it's uncertain. The insurance could actually change, or it could be void, in which case you have zero liability. And if you have zero liability, it could be unreasonable and therefore unenforceable under what Tom was talking about before, the Unfair Contract Terms Act. But as far as the insurance, whether the insurance would be invalidated, that is a matter for the insurer and to check out the insurance. What we tend to advise is that the cap is linked somehow to the insurance cover. We don't actually say that in the contract. We don't say whatever the insurance is, that's the cap. But if the insurance, say, is 5 million in aggregate over the year, then you might pick a figure, say 1 million, 2 million, leaving something left in the pot, but you're basing it on the insurance. Because one of the key issues that a court would look at to detect whether a clause is reasonable or not as a liability clause is whether a party had insurance. And if a party did have insurance and didn't have any liability cap close to the insurance, a court may strike out that liability cap as being unreasonable and therefore unenforceable, and you could end up with unlimited liability. So I hope that was clear. I don't know if that was, Tom. I don't know if you've got any thoughts to add to that.
No, I don't. No, good answer. Yeah, I don't have anything to add.
Okay. Okay, thanks, Tom. And another question here, and I think this is one for Regina. Is it common or reasonable to stipulate that contract acceptors take out insurance products back on insurance again for certain contingencies, such as contamination or loss of GMP status?
It's not common because in most cases the contract acceptor will argue the point. They will have a limited amount of liability and they will take out a limited amount of insurance. I suppose if I can give an example, recently I've was reviewing some documentation where we had seen some products inbound shipment into the UK. It was quite a large volume, and the product was damaged during transit due to the onboarding of some illegal immigrants. The product was damaged. It was quite high value product, but the insurance of the contract acceptor where the product was delivered and they were responsible for the transportation was very limited. So in terms of recouping your insurance, it was very, very small, because they will not cover the cost of the consequences of GMP or contamination in most cases.
Thank you very much, Regina. Another good answer. Now we've got, I think this is quite an interesting question. It says, could there be a product liability claim even if the product is not defective and complies with the specification? So I'm going to start with Tom, see if Tom's got any thoughts on that. If not, I can chip in with some thoughts, and we'll see if Regina's got any. I think this could apply to all of us, really. Tom.
Well, if you're happy to pick that one up.
So, yeah. Well, from a contractual point of view, the contract sets the contractual standard. So it depends really what the contract says. So if the contract says that the product will conform with its specification, and if it conforms with the specification, then it's done. The supplier's done their job. Then I think it becomes a moot point as to whether there's a breach of any other obligations in the contract, such as the obligation to take reasonable skill and care. And then the standard would be to look at whether it was reasonable to have delivered the product that was delivered. If there was something that was an unanticipated side effect, then you could say that there's no liability for a breach of skill and duty to take skill and care. But there's also the question of any sort of product liability and whether that is passed up the chain in some way. So under the Consumer Protection Act, there is strict liability of offences. And that's a question for between the person who suffers the loss, as opposed to going up through the contractual chain. That's a matter between the person who suffers the loss and the person who is ultimately liable for that. But that's less a contract claim, more a claim under strict liability under the Consumer Protection Act. But it's a really interesting question. So I was about to say the name, the person who asked that question. And I think it opens more questions than it actually answers. Regina, from a quality perspective, do you have a view on that?
Well, I mean, if the product meets its specifications, is that just the testing specifications? But you have to consider, was the supply chain compliant? So was it moved or was it manufactured in a GMP environment? So if we take, for example, if they subcontracted manufacturing of a product to a facility in India, if that wasn't a licensed facility, was the product they import maybe test to meet the requirements? It doesn't meet the requirements because it doesn't meet the requirements of the dossier. So I suppose it's just getting clarity around what's referred to as, meeting requirements. Is it just the label storage requirements, or is it the integrity and intact GMP supply chain?
So Regina, that's another good answer, and I think we seem to be in agreement on that one, which is that it really depends what the standard is in the contract or in the technical agreement. That's going to define whether someone has liability or not, and it's possible that there could be unanticipated side effects whilst the manufacturer has actually complied with everything in the contract, in which case, unless there's some other obligation in the contract that is a stricter liability, then the manufacturer has done what they should have done.
I suppose, Paul, just to add there, so if there is a problem, if there's an untoward event or a side effect, ultimately the responsibility lies with the marketing authorization holder.
Yeah, absolutely. Okay, Regina, thank you very much. So Regina Dawkins, PharmaLex, Associate Director, Senior Consultant at PharmaLex, thank you very much for your input today. Very helpful. And same also to my colleague, Tom Cahill at VWV. Really interesting session. I hope you'll all agree.